Good afternoon, everyone. I'm Vikram Sachdeva, and I'm very pleased to welcome you to this webinar on a local authority in JB, in which the Supreme Court handed down their judgment yesterday, as I think you know. I will introduce our speakers in a minute, but just before I forget, if you wish to ask any questions, which we'll seek to answer afterwards, do use the Q&A function. Okay, so that's how you ask questions. So I'm very pleased to introduce Nicola Kohn, Ian Brownhill and Parishil Patel, who will be giving brief talks on this judgment, and then there'll be a Q&A session with all of us and Alex Ruck Keene. So without further ado, I'd like to introduce Nicola Kohn. Nicola.
Hello, everybody. I'm going to try and share my screen now so that you should be able to see some slides that we've got up there. Yes, excellent. Okay, so I'm going to go briefly through the facts of the case before Ian and Parishil, both of whom were in the case, along with Vikram, of course, will go through some of the other details of the wider implications. Sorry, I'm just fighting with Vikram over the mouse. So, first of all, the facts of the case. The case, of course, concerned JB, and I'm conscious many of you may have already watched Alex Ruck Keene's masterful rundown of the case. If you haven't and you're interested, I recommend having a look at that after this. But JB is now a 38-year-old man. At the time the litigation began, some 2 years ago, he was 36, of course. He suffers from severe epilepsy. He's registered blind, and for the last 20 years or so, 10 years or so, he has been diagnosed as suffering from Asperger's syndrome. He lives in community supported living funded by his local authority with two other individuals, and he's lived there for I think around 7 years. He's deprived of his liberty by the care plan that under which he's cared for there. And part of his care plan is that at all times, and particularly when he's accessing the community, he is supported by at least one care worker. Part of that, of course, is that fundamental to this case and to JB's presentation is his inability to understand the motivations of others and thereby to manage his contact with them. The judgment looks specifically at his recent adulthood and the effect that his severe epilepsy, which he's had from childhood, has had on his cognition, such that from reading the judgment, and Paul Vikram will correct me if I've got any of this wrong, he's not learning disabled, but he does suffer from an impairment of the mind, in part due to these repeated epilepsy attacks that he's suffered throughout his life. The judgment here cites extensively from the evidence of a clinical psychologist, Dr. Thrift. And one of the things that she talks about is the difficulty that JB has in terms of learning how to understand and interpret the subtle nuances that you experience in social interaction, particularly in the intimate interactions that one has during sex. And she notes that his number one priority is to get a female partner in order to have a sexual relationship with her, but he's not particularly interested, she knows, on the companion side of the relationship. He simply wants to initiate a sexual relationship. And this is part of the motivation for the application in the case, because JB, we learn from the judgment, has a history over recent years of approaching women in order to initiate sex, of focusing on particular individuals and not understanding what is and isn't appropriate behaviour. And when asked by Dr. Thrift about the other person withdrawing consent during a sexual act, JB says, well, that's a tricky one. If the person gives consent, then she's already given consent and you have to go through with it to the end. Once you're halfway through, she can't say, I don't give you consent, because she's already doing what you need to do. So he clearly, she concludes, doesn't understand both that a sexual partner needs to give consent in order for sex to be initiated, but also needs to keep consenting throughout the act. And part of that is illustrated by one of the exchanges that JB has with Dr. Thrift that's reported in the judgment, when she asks him, well, if a woman gets drunk at a party and has sex with somebody else, does that render her fair game? And he says, well, yes, If she's done it with one person, if she drinks enough, she's bound to do it with a second one too. And crucially, Dr. Thrift and the other, there's a second psychologist who also gave evidence in the course of the initial proceedings, said that one of the difficulties was that both Dr. Thrift and Dr. Peters considered that JB didn't have the ability to learn from education that he was given, and showed a little interest, little motivation to learn more about the process of understanding consent from others. Now, at first instance, before Mrs. Justice Roberts, the official solicitor succeeded in her case, arguing that the question of whether or not the other party did or did not give consent to sex was not part of the relevant information that JB needed to understand. The local authority appealed, and that was heard before the Court of Appeal last year, at which point the Court of Appeal, in the leading judgment of Lord Justice Baker, switched around the question and said, well, the question isn't so much does he have capacity to consent to sex, particularly, it seems to me, in the situation where we're talking about a man, does he have capacity to engage in sex? And answering that question, the Court of Appeal set aside the judgment of Mrs. Justice Roberts because she had concluded and made a declaration that he did have capacity to consent to sex, and said, well, in fact, in circumstances where he doesn't understand that the other person must consent to and continue to consent to sex, then he can't have capacity to consent to sex, albeit that I should clarify, the Court of Appeal didn't make a final declaration, made a Section 48 interim declaration as to JB's capacity, and remitted that decision back to the first instance judge for her further consideration. And then, as we all know, the case was heard this summer before the Supreme Court, and the panel handed down judgment yesterday. Interestingly, it's Lord Stevens, Lord Briggs, Lady Arden, Lady Rose, and Lord Burrows. And it's the first, as far as I'm aware, it's the first time the Supreme Court has considered capacity, and obviously it's absent Lady Hale, and I suppose the only one with a significant family background is probably Lord Stevens. But in any event, they handed down judgment, and they upheld the conclusion reached by the Court of Appeal, which was that the relevant question is whether the relevant matter is whether or not the other person does understand, whether the other person does consent to sex and continues to consent to sex all the way along. And Lord Stevens, who gave the judgment, gave the leading speech, said, in this way, the matter for decision relates to sexual relations, but does not relate to a particular partner, time, or place, so that it is non-specific, as in this case, because JB wishes to engage in or consent to sexual relations with any woman, then the non-specificity of the matter will inform the information which is relevant to the decision. And he went on to say, pragmatism does not require that consent to future sexual relations can only be assessed on a general and non-specific basis. Furthermore, such a restriction on the formulation of the matter is contrary to the open-textured nature of Section 2.1 of the Mental Capacity Act. A general and non-specific basis is not the only appropriate formulation in respect of sexual relations, as even in that context, the matter can be person-specific, where it involves, for instance, sexual relations between a couple who have been in a long-standing relationship, where one of them develops dementia or sustains a significant traumatic brain injury. It could also be person-specific in the case of sexual relations between two individuals who are mutually attracted to one another, but who both have impairments of the functioning of their minds. And that's not working. What? Let's see. And he went on. That was the first time. I thought that was quite a long way without a slide failure. And he went on. I won't read it all out, but you've got it there in front of you to talk about the reasonably foreseeable consequences of a decision, including the implications for P if he hasn't understood properly that the other party needs to consent. And he said, in this case, there are reasonably foreseeable consequences for JB of a decision that to engage in sexual relations such as imprisonment, and I forgot that, imprisonment for sexual assault or rape if the other person does not consent, there are also reasonably foreseeable harmful consequences to persons whom JB might sexually assault or rape. And one of the themes that runs through the case is the extent to which, and I'm sure Parishil and Ian will talk to you about this, the extent to which the wider societal implications of P's capacity to engage in sex merit consideration. So in terms of the formulation of the matter, and this was the crux of the decision by the Court of Appeal upheld by the Supreme Court, the question of whether consenting to or engaging in is the key question, which was one of the grounds of appeal by the official solicitor. The court held the function of section 27, which is of course the section of the MCA which precludes sexual relations from being a decision on which the court can make a best interest decision. The function of section 27 is to identify certain decisions which are so personal to the individual concerned that no one may take them on his behalf if he is unable to make them for himself. And he goes on to say section 27 only makes clear that where a court finds that a person lacks capacity to consent to sexual relations, then the court does not have any jurisdiction to give consent on that person's behalf to any specific sexual encounter. And he held that it didn't preclude the court from making the kind of decision that it did here, that that capacity to engage in sexual relations is the key question, not capacity to consent. Now, I'm mindful of the time and that there are lots of other people that you need to hear from. I just finish off by saying that the two other issues that the court decided against were the question of Article 8 and the CRPD. And the final thing, which I did want to raise your attention to, is that there are two fantastic easy read summaries available on the Supreme Court website, which I hadn't seen before. And obviously they're not entirely intended for barristers, but I found them very useful. Anyway, I shall stop sharing and hand you over to, I think, Ian.
So for me, the culmination of the case of JB is about 4 years of work. And today I'm going to turn 4 years of work into something which doesn't only apply to JB's case, because of course that's now ongoing. It will go back down to the High Court for his capacity to engage in sexual relations to be determined. But hopefully take that amount of work that we've been doing in the High Court, the Court of Appeal, and now most recently the Supreme Court, and turn it into something or translate it into something which I hope is accessible. So the first hurdle which I have to pass is being able to share my screen, but hopefully you can now see on the screen a slide which sets out, which I hope is some sort of structure moving forwards as to how we approach the question of whether or not somebody has the mental capacity to engage in sexual relations. And in respect of that, the starting point right at the top here is actually, as in every capacity assessment we do, determine what the sexual matter to be assessed is. So determine what is the question we're assessing capacity for, what's the decision that the person themselves has to make, what is it that we are doing an assessment about. And what we know now, looking at the Supreme Court's judgment, is that the usual course will be for an assessment as to whether or not P has capacity to engage in sexual relations. So that will put us down this branch here, and most of our assessments will follow down through this line. I just want to talk about those assessments which don't follow down the usual course, because now every time we assess capacity to engage in sexual relations, we'll have to ask ourselves, is this a case where we can apply that formulation? Or is there something specific about it, about the particular scenario with which you're assessing, that forces you down a different route? I.e., is there something unusual about it? So if there's something to force you down the usual, away from the usual route, then what both the Court of Appeal and the Supreme Court do is accept implicitly, but perhaps don't set the boundaries of it, that there is a remaining category where you could assess capacity to consent to sexual relations. Now, I don't predict what that capacity assessment looks like or what that group of cases would look like. But it's really important, of course, that Lord Justice Baker and then Lord Stevens both kept open potentially that open category. And one of the conversations we were having today was, well, if you're not going down the usual line of assessing whether or not P has capacity to engage in sexual relations, what other types of sexual act or sort of sexual factual matrix or sexual scenario could you be looking at which forces you out of that usual line which we have down here? And of course, there have been particular cases about particular different scenarios. So there's been a case about autoerotic asphyxia before the court. There's been other cases about various other forms of sexual fetishism, again, which may find you outside of the question as to whether or not P has capacity to engage in sexual relations and into this area here. But if you're not in that area, if you are dealing with what dare I say is a day-to-day case about engaging in sexual relations, again, it's not as simple as just saying, here's the relevant information and applying it to P in a generalized, generic sense. So again, what happened in the Supreme Court was that there was a decision made whereby it was accepted that for the most part, the course that an assessor would be taking and ultimately the court would be taking would be to take a generalized view as to whether or not P has the capacity to engage in sexual relations. So that is an open decision looking into the future. It doesn't necessarily relate to a particular sexual partner. So the usual course will be to do this almost, I don't want to use the word generic because generalized is better, but this broad assessment as to whether or not P has capacity to engage in sex. And in those circumstances, you will apply the generalized test of the relevant information to engage in sex as is set out in the judgment. And that will include P themselves' ability to consent to the sexual act, but also P's understanding of their potential partner's consent and the need for that consent to exist and continue to exist throughout the sexual act. So the usual course, if you like, in most cases, will be to follow through here. So it will come down from here, generalized assessment as to whether or not P has capacity to engage in sexual relations. However, what's been left here is a safety valve that Nick was just talking about, where she was talking about the circumstances that Lord Stevens said, where there might be something particular about P or about their relationship, whereby effectively you can contextualize the relevant information because you're applying it to that particular matter. So if you had a scenario whereby P was in a monogamous relationship or P was in a homosexual relationship, you might be able to remove parts of the relevant information that don't apply to their particular circumstances. For example, if someone is in a homosexual sexual relationship and there's no risk of pregnancy as a result of that, then why would they have to understand that or use and weigh it in the process engaging in sex? Likewise, if someone's in a monogamous relationship and there's no risk of sexually transmitted infection, why would they have to understand or use or weigh or retain that? So whilst the yellow line there, drawn perhaps inelegantly across the page, shows what the usual circumstance now is in these cases when we come to assess whether or not someone has capacity to engage in sexual relations, we are left tantalized still perhaps with these two prospects. The prospect, firstly, that the type of sexual act or the type of sexual engagement would take you out of that normal, if you like, generic assessment and put you over here into a scenario where you're assessing a particular scenario where you need to apply a different set of relevant information that reflects the matter you're actually assessing, and the scenario where a sexual relationship contours or changes the contents of what the relevant information is to reflect the situation for P on the ground. And I suppose it's these two areas which are going to be where there's future litigation in the higher courts, because they will be the ones where the court is considering how it's applied in future, considering the judgment of not only the Supreme Court, but also the Court of Appeal in JB. Thank you very much. And I'm now going to stop sharing and hand over to Parishil.
Thank you, Ian. I'm going to talk to you about the wider implications of the Supreme Court judgment. Hopefully now you can see, this. It's perhaps surprising that it's taken so long for the Supreme Court to consider how one should approach decision-making capacity. It's been 14 years since the MCA came into effect, and this is the first time the Supreme Court has had a chance to consider that question. But it's perhaps unsurprising, given how long it's taken to reach the Supreme Court, that the Supreme Court felt that it could make a number of observations which have wider implications, even though the appeal in question was concerning the test in relation to sexual relations. Now, some of those wider implications, as we'll see, are fairly established propositions and fairly non-controversial. Some of them, on the other hand, are perhaps probably considered to be controversial. I'm just going to take you through some of them. Let's start off with the established. What Lord Stevens did was provide a useful and succinct commentary on the cardinal principles enshrined in Section 1 of the Mental Capacity Act. All of us who've been well familiar with the Act will know these principles. We'll have had them to heart and we'll talk about them in many of our cases. But what he does quite usefully is set them out and provide a very kind of deep, succinct summary of them. It's worth looking at that at paragraphs 49 to 53. The second thing he did was he confirmed that the Mental Capacity Act's approach to capacity and to determining capacity was a functional approach. So it wasn't an outcome approach or a status approach, and he took some time to say why they were not the approaches taken. And he said, no, what we have here is a functional approach to capacity. The third thing that's pretty established and pretty non-controversial is the actual test in Section 2.1. He called it the core determinative provision. And he says that that's the test. That's the test one has to apply in Section 2.1. The rest of Section 2 and Section 3 are statutory, what he called statutory descriptions and explanations which supported the core provision. And therefore they were not additional freestanding tests, and the only test was the one at the beginning of Section 2.1. And then lastly, in terms of the established non-controversial observations, he said there were two stages to the capacity, Section 2.1 capacity test. The first, as you know, is whether P is unable to make a decision for himself in relation to the matter. So the functional part of that test. The second is whether that inability is because of an impairment of or disturbance in the functioning of the mind or brain. In other words, what we all know as, is there a clear causative nexus between the inability and the impairment? Now, all of that is pretty uncontroversial. It's pretty established. It says nothing, Lord Stevens said nothing different to what was said in the Court of Appeals case of City of York. I move on to what are probably less established observations and probably slightly more controversial. And those are two issues. The first is in respect of the first question, the formulation of the matter in hand and the need to formulate the matter precisely. And in JB's appeal, the options before the Supreme Court, and in fact before the Court of Appeal, were between engaging in sexual relations, defining it in that way, and consenting to sexual relations. And Lord Stevens agreed with the Court of Appeal that the relevant matter should be properly formulated, at least in JB's case, in respect of engaging in sexual relations. What he said, by way of a more general observation, in my view is plainly correct, is that one, you need to be precise about the way in which the matter is formulated, because that was of fundamental importance in JB's case, because he couldn't understand the matters that were relevant to engage, but he might have understood all the matters relevant to consent. But the Supreme Court emphasised that the formulation had to have regard to the specific factual context of the case. And that brings us then to the second issue, which they made general observations about, which is the need to identify the information relevant to the decision, and in particular, information about the reasonably foreseeable consequences of deciding one way or other or not deciding at all. And that it was, in the Supreme Court's decision, controversially not limited to reasonable foreseeable consequences for P, because what Lord Stevens said is he said it can extend to the reasonable foreseeable consequences for others. So in other words, within the factual context of the matter in hand and of each case in hand, one needed to look at what the reasonable foreseeable consequences were of making the decision one way or other, failing to make the decision, in respect of consequences for both P and for others. Now, that, I think, was the first time that that particular proposition has ever been articulated explicitly in case law concerning the MCA. But it, in my view, makes quite a lot of sense, because within the factual context of each case, and we've seen this most clearly in decisions relating to contact, we know from the Court of Appeal's decision in City of York that what one is talking about in contact decisions is the factual scenario which gives meat to the decision. And sometimes that would include looking at the point of view from the perspective of a particular person for whom P might have contact, which is why Lord Stevens said in JB's case, although it didn't apply to the facts of his case, it may, in relation to other cases, be quite apt and quite sensible for relevant information to relate to a specific person when one comes to sexual relations. So what he was doing there was saying, well, a person-specific assessment may well be appropriate because it depends upon how one would then define the matter in hand. That then probably leads us to the most controversial part of the Supreme Court's decision. One of the arguments that the official solicitor raised as to say that one couldn't have as part of the relevant information that you had to have an understanding of the other person's ability to consent and the fact that they were consenting throughout. It's quite a mouthful, that relevant information. But one of the reasons why the official solicitor said that was wrong, both in the Court of Appeal and in the Supreme Court, was because that then meant that what the MCA was doing was, the purpose of the MCA in that regard was to protect other people. And they said, well, that's not the purpose of the MCA. The purpose of the MCA is to protect P, it's concerned with P. Well, Lord Stevens said and agreed with the Court of Appeal and said, well, no, sorry, you're wrong about that, I'm afraid. I don't agree with you that the purpose of the Mental Capacity Act is solely confined to the protection of P. And it may be that that's in that respect, as those of you who are mental health lawyers will know, that is pretty or could be pretty controversial. Now, it may be, in my view, that Lord Stevens, his formulation in that, or proposition or rejection of the submission of the official solicitor, is saved from proving too much by the words he uses solely. So such that in JB's case, and in cases where a particular person cannot understand that the other person isn't consenting or hasn't got the ability to consent, that would protect that person, P, because otherwise, if they tried to have sex with them, they would be committing some sort of, or could be committing some sort of offence, or could expose themselves to the risk of some other harm. In which case, it's not simply about protecting other people, it's also about protecting P. And it matters not that one of the purposes is to protect others. But I leave you with this, which is the thought that I was having when I was considering this, which is that if the purpose of the MCA, as we know, is to enable sort of parity, as it were, between those people who lack capacity, or with mental disorder who lack capacity, and those people who have capacity. In other words, the MCA is there to allow people to make the same decisions as people who have capacity. It's very unclear why it is that the protection of other people would need to be a purpose in that respect, because for people with capacity, if you were going to commit a crime, as it were, of trying to have sexual relations with someone who wasn't consenting or didn't have the ability to consent, no court or no tribunal could tell you otherwise until you found yourself in front of or found yourself the subject of criminal proceedings and found yourself in a criminal court. And to that extent, that isn't parity and isn't something that should be the responsibility of the Mental Capacity Act. But as I said, I think Lord Stevens may well have actually covered himself to that result by the word solely. I think I've rather sort of moved through what I wanted to say rather quickly. I'm sorry if it was too quick. But I think that's probably all I want to say at this stage, but I'm very happy to answer any questions. Thank you.
Right, that's great. Parishil, can you unshare your screen?
Yes.
And then we'll see who's around. Right, so we have got some questions in, but I'd like to open it up to, if you mind first, which is, first question is, and I know who I'm going to ask it of first. Do you find this outcome at all surprising? And I'm going to ask Ian Brownhill first. And you're not allowed using expletives.
Do I find it at all surprising? So I'm obviously not going to talk about JB in his particular circumstances. I don't find necessarily some of the core decisions to be surprising. What I do find to be surprising is that there are perhaps some unanswered questions. And I think that there were parts, in fact, Mr. Sachdeva, of some of your oral submissions that weren't answered in the judgment. And perhaps there are those aspects that I set out earlier on my little roadmap, which I think there's still going to be litigation about. So I perhaps found that surprising. I thought that perhaps, although the issues didn't arise, I perhaps thought that some of those questions would have been cut off. And I thought that perhaps we would have had a more definitive suggestion or answer as to when we would go for a more person-specific type scenario.
The next person I'm going to ask is Nicola. Nicola, what do you think? You are possibly more objective than Ian or myself or Parishil or Alex.
Yes, as the wasn't in the case. You've muted me. You've muted us.
No, you're unmuted.
Yeah. No, it says we're muted. Okay, fine. I think it's interesting. I made a comment when I was speaking earlier that JB is male, and one of my key involvements in a similar case, Manchester and LC, which concerned a woman, and concerns by the local authority about how you manage an attractive young woman who wants objectively to have sex with a lot of people, and how the question is there. And in that case, the suggestion that the real question should be capacity to engage in rather than consent to clearly never arose, because that the concern there was to protect LC. It wasn't about the wider community. And so I think a lot of the questions that arise in that kind of case are still unanswered by this, because you're looking at it from, you know, an active participant seeking sex. And I'm not sure that it completely answers, as Ian has said, all of the other questions that arise when you're talking about a vulnerable P consenting to sex, because you've just changed the question, but I don't think you've necessarily completely answered the initial consent to question, which must still remain, albeit that I recognise the Supreme Court says, well, they're both subsumed into each other. I think there's still an open point there.
Parishil, surprising result or not?
Always surprising, Vikram, when I lose a case, as you know. But no, I think
happens very occasionally only.
Well, it's true. I think actually once you do work out the intuitive point that those of us about whom there is no issue about their capacity do, when deciding or when having the ability to decide whether to have sex or engage in sex, do understand that someone has to consent to it if you're going to do it, and that they are consenting to it, then it becomes less surprising. I think the route to the answer is perhaps slightly convoluted, but I don't think, for instance, the Supreme Court needed to really make any observations about protection of others in order to get to the answer they got to, and so therefore they've said something, as it were, sort of probably slightly obiter, which is going to then cause problems in other contexts. So yes, probably the right answer. No, I'm not surprised by it, but I'm worried about some of the implications.
Right, Alex.
So I'm in an odd position because I actually haven't done sex cases before until I came in to be one of your juniors in this case before the Supreme Court. And so what I find, I have to say, really surprising about this is that when you really take a step back and look at this, you do start to ask, why on earth did we start asking questions about sex at all? And I think it's extremely interesting that we started asking questions about sex, essentially because Sir James Munby, in a case where it didn't actually fall for consideration, started talking about it.
Well, he's the one that started it off.
Well, he did. And because he started talking about it, people started thinking, gosh, we need to think about sex. And once you start asking questions about sex, you start getting yourself, and there's some very interesting questions in the chat function about basically what on earth are we supposed to do? And in some ways, this is down to the fact, I think, that a whole industry arose of thinking about people's ability to make decisions about sex in the abstract. And then you go, what on earth am I supposed to do with that information? And what's really interesting, of course, is in JB's case, he does not have capacity on the evidence before the court, and he does not have capacity to make decisions about contact, and he's subject to a care plan which restricts his contact. And so it is interesting to be in a situation where we spent an awful lot of time thinking about sex, and we've driven ourselves into some very, very interesting sort of areas. And I think Nicola's point is extremely powerful about why do we think about sex potentially differently, depending if we're thinking about a woman or if we're thinking about a man. I think it's really, really good that the Court of Appeal and then the Supreme Court changed the goalposts to thinking about engaging, not consent. Because what really bothered me about capacity to consent as an outsider is I wasn't doing
thought of that, Alex?
I couldn't possibly comment. But it might have been somebody in a newsletter report said it seems a bit weird talking about consent, because that starts to suggest that people with disabilities are generally only passive recipients of others' enthusiasms. Whereas these are individual cognitive impairments have got their own desires and wishes. And it is really, so it seems to me that the engagement aspect is really important. That reflects that people with cognitive impairments may well be active, not just, as it were, people solely to be protected. But you then end up with this very interesting, very challenging thing that we're really spending an awful lot of time thinking about sex, when actually you might be thinking, should we really be thinking about this? Or should we really be thinking about someone's ability to make decisions about contact? And if we're thinking about decisions about contact, is someone able to protect themselves? Or are they in a position where they might be causing a risk to others? And into the mix there, you might go, well, what does this person understand or know about sex? And that was floating around before the Supreme Court, but the Supreme Court, partly because everyone was saying, this is very important, we need to think about sex, then comes up with those conclusions. The only other point I would make, so I don't think it's a surprising conclusion at all, the only other point I would make is that this case also really reinforces for me, quite often the mental capacity test is not where we should be starting at all. What the Supreme Court are really saying is start with the duties on the state. The duties on the state arise under Article 8, Article 3, things like that. We have to think about how to protect P. We have to think about how to protect others. And yes, the eye of Sauron doesn't automatically descend on everybody, but when the eye of Sauron has descended on somebody, they've got to think about how to juggle these different duties. And of course, that then gets reflected through the prism of capacity. And once it gets reflected through the prism of capacity, it seems to be blindingly obvious that that has to include other people's interests. And it makes clear the MCA was never purely about the person's own interests. Very long answer to that question, sorry.
So what do we mean about sex in general? What do you see as encompassed by the concept of sex in this judgment? What does it cover? That's one of the questions we've been asked. I think we're up to 24 questions in the Q&A.
Well, Vikram, if I answer that, I think what we mean about sex is all recognised sexual activity. It has to be. What do humans recognise as a sexual activity, and what do they recognise in that respect? And then you've got to make a decision about whether someone has the capacity, if they want to indulge in that, whether they've got the capacity to do that, engage in it. But can I just go back to the point that Alex was making about the sort of relationship between sex and contact? Because Alex, that was the very argument that we raised in the Court of Appeal. And I'm saying this not because I was the one who raised it, but because
part of the reason, isn't it?
But because we said, look, you don't need to make sex, the test for sex, so difficult and higher the test, because actually all of these risks that you're talking about can be dealt with in relation to contact. And the only point that came back, it seemed to me, that couldn't really be answered by us on that was that in the middle of sex you can say no. And so how would you then protect someone if they're already in a private room, as it were? And you could only do that by saying that the test for sex is the one where you have to understand the other person's consent. But we were raising this issue about contact, and we were raising this issue about the relationship between contact and sex. And I think that the Supreme Court does touch on that, because the whole point of person-specific and factual circumstances is borrowed from, is it not, from contact? Because everyone's saying in order to give that decision some context, you need to understand what the actual context of the decision is. And that must apply just as much to sex as it does to actually other contact. Sorry, I answered the sexual activity question rather more briefly than that, but that's what I wanted to make.
So interesting question on the Q&A. Decisions are time and decision specific. We can't expect everyone to police this. Whenever P wants to have engaged in sexual activity, is someone going to be there to assess P's capacity at the time he wants to engage in that activity? Ian?
So I think this is purely a practical answer rather than a legal answer. The way it's been conceptualized in a number of cases has been that where P has a package of care, that there would be prompting and there would be discussions with that person's carer before they went off to engage in sexual relations. However, my practice is very much like Nicola's practice, and we both deal with cases where we have vulnerable people who are engaging in highly risky activity, who often abscond from their carers, and it almost seems to become a sort of irrelevancy. So I agree with the person who posed the question. I think it's very difficult in those circumstances to take a view at that particular point as to whether or not the person truly has capacity. And I think really the sort of tests we're talking about are much more suited to more perhaps I don't want to use the word sedate, but more predictable sexual relationships, rather than that group of perhaps younger Ps who can find themselves in very vulnerable and potentially positions where they're exploited. But again, I would almost argue that would again come back to questions as to contact and care rather than perhaps sex.
Okay. One question that I think many people have is, what is the difference between capacity to engage in sex and capacity to consent to sex, Alex? If any, I would add.
I think you should answer that.
I'm just chairing.
Well, I'll take a first run at this. One thing Lord Stevens says is very clearly, engage includes both, as it were, initiate and consent. So it includes both aspects. I think the other aspect is...
Can I just stop you there?
Yeah.
Why would you say consent didn't include initiating?
I think that Lord Stevens was attracted by what the Court of Appeal had said, which is consent has a flavour of I am agreeing to something else proposed by someone else. I think that's really what he was attracted by. I think the other thing is it's important, seems to me.
That's true. Sorry, on contact, would you say that was true with contact? Consent to contact, does that imply the other person suggested it?
Yes, definitely, to me.
Right.
I mean, I think part of this is also down to, and there was a very important bit in the judgment, which is about how this intersects with the criminal law. Because one of the things the official solicitor seeks to do, and I think it's really important to flag this, the official solicitor essentially throws almost every single thing you could possibly think of at the Court of Appeal's judgment. Every single tool is thrown at the Court of Appeal's judgment. And one of them is, you are creating a total incompatibility with the criminal law. And Lord Stevens just says no, and then gives a number of reasons why he doesn't think it's, well, he says, I recognise we may end up in a position where things mean different things for different purposes, criminal purposes and civil purposes. And actually what he does is he goes back and engages in some textual analysis and saying, just because the word, for instance, capacity appears in one place and the other, it doesn't automatically mean the same. And there was a lot of material before the Supreme Court about legislative history. But it seems to me that one of the things which is going on is that this case might enable us to go back and reflect that consent makes a lot of sense in the criminal context, because you were asking, did this person consent to this act at this point? Because there's an identified perpetrator by definition. I mean, whether or not they actually carried out the act is something else, but somebody is saying there is a victim, there is a perpetrator. It looks like consent. That's just conceptualized through the criminal law. And it seems to me that consent previously in the civil law on the mental capacity outside was being stretched to cover something which most people probably wouldn't have said is consent. I mean, I can wave a great big book about consent in the law before the camera, but I won't. But I do think this case provides a useful opportunity to take a step back and say, did we allow the word consent to stretch to cover actually more than we potentially needed it to? Does this case give us the opportunity to take a step back and say, when you're thinking about someone actively doing something, it looks like engagement or deciding to engage. And when we're talking about a medical procedure, you don't engage in a medical procedure, you consent to something being proposed by a doctor, is at least my take on it.
Okay.
I would have thought,
sorry?
I would have thought, Vikram, that if you were looking at consent, that you just look at the natural meaning of consent, which is you choose to do something. Do you consent to do it? You choose to do it. And that's where I had a little bit of an issue with the sort of engage consent formulation, because to me, it was, if you choose to do something, you can be the initiator just as much as you can be the recipient of something. I thought that if one was looking at capacity was whether you decide to exercise your choice, right? You know, whether you have the ability to decide to exercise your, or to make a choice. And that's why I thought the consent of the other person shouldn't have been part of the test, which is why we were arguing that, or partly why we were arguing that. And I don't know if the Supreme Court has ever, or the Court of Appeal in that way, ever gave a coherent answer to that, i.e. the difference between actually having the ability to choose and choosing.
Yeah, no, I think that's a very good point. Does anyone else have anything to say on this point? If not, I'll move on to possibly one of the more controversial aspects of the judgment, which is the significance of the protection of others and others' interests under the MCA. And I think this is the first case that's really squarely addressed that issue. And the question I'm going to ask is, do you think there might be wider implications of that high level of generality principle, which is, I think, something that not everyone anticipated? So I don't know, Nicola, if you've got any views at all about whether, first of all, it's surprising that the interests of others is something that's a legally relevant factor at all in determining capacity. And secondly, whether there may be implications for other cases, or whether you think it's likely to be just restricted to this case, and most weight is placed on what's good for P in all other cases, just a last resort principle where the court can't find another reason to do what it wants to do.
Yeah, I think probably all of that element of the judgment, it seems to me, is overture. But in any event, I think the incorporation of the protection of others into the capacity assessment, to me, is surprising, and it's something that I would anticipate more in the MHA sort of jurisdiction than in the MCA jurisdiction. And obviously, we've talked about, you know, the sort of responsible citizen element of best interests and so on in the Skripal case, and I think that was one of your submissions in that, Vikram. But having it into the capacity test, I mean, I suppose, sort of standing back objectively from a layperson's perspective, you might say, well, of course, and particularly when you're analysing a question like this, which has such policy implications, why wouldn't you want to consider what the implications are for P? And particularly if you think of the Secretary of State for Justice in a local authority case, which concerned more about sex workers and potential for violence and all of that kind of thing, why wouldn't you want to consider the implications for a wider society? But I think from a strictly legal perspective, it was surprising to me. And I think quite a lot of the cases that I work on, and probably Ian as well, will now take a slightly different bent, particularly, you know, when you're thinking about community access. You know, if you have a P with difficult behavioural aspects, how is that going to be affected? And I think it could be significant.
Parishil, what do you think? You're muted.
I do, as I said in the talk, worry about what that line at paragraph 92 of the judgment could lead to. But I think, as I said, that he saves himself, I think, with the word solely. But I think that it comes from, as I have worked it through in the judgment, it comes from the fact that he says that reasonable foreseeable consequences can relate not just to P, but also to others. And that probably has to be right, because if one thinks about other questions, not just sex, but other questions such as contact, you are thinking about risk to others. You are thinking about the way in which your contact would have an effect on others. And so why should sex be any different in that respect? And therefore, once you've concluded that the reasonable foreseeable consequence in someone's specific circumstances can include those foreseeable consequences to others, you're then on the slope of saying, well, actually, the MCA can't just simply be about protecting P. It has to be to some extent about protecting other people. I think the difficulty will be how far one goes in that. You know, if the protection of the court of protection and making a decision is predominantly somebody else rather than P, is that an acceptable justification of the exercise of powers under the Mental Capacity Act by the Court of Protection, or would that be going too far in terms of what the legislative purpose of the Act is? Again, it creates more problems. It will create more legislation, I suspect, before we can work out what it all means.
Ian, anything to add to your erstwhile leaders' announcements?
Just what I've expressed a concern about, and I know that Alex takes a different view from me perhaps, is that I can see the sort of combination of this part of the judgment and earlier decisions like ZZ, and people taking it upon themselves that they can impose restrictions for a public protection
An
purpose.
SR, for instance.
An
What
SR.
about the implications for doles? Are there any?
Well, it may well be seen that way. And one of the things we've already seen, Vikram, that's, before this judgment even came out, we've already seen multidisciplinary teams where there have been relationships between local public authorities, where the police have put pressure, and in one case, the probation service have put pressure on social services to implement restrictive care plans to protect the public. And what worries me is that this judgment won't be read as Parishil has suggested, and will be read in a way that seems to enable a public protection imperative. And I think that's wrong and not what the Act intended.
Can I just make one observation, because I know we're almost out of time, but one thing I really want to say, which is really, really important, is doles has a statutory limitation that you are only supposed to be considering necessity and proportionality by reference to risk to the person. So if you're in doles land, you really can't be wandering around, as it were, doing whatever you want. I completely agree. You might well get to a situation where the Court of Protection feels more comfortable about doing things which feel like public protection. But that's important. That's the court doing it. That's not people saying, I'm using doles for public protection. I think it's just really, really important, because there are loads of questions in the chat function and people aren't left with thinking this necessarily tracks through automatically into doles.
Right. Okay. Well, I think with that, our time is now up. So I'm going to thank everyone for watching. Thank speakers for a very interesting talk on this case that clearly has very wide implications in best interest law in general. And we will seek to answer some of your questions in the chat function in writing. So thank you very much and good afternoon, everyone.